Okay, thank you very much, Pierre. Appreciate it. We are online, so be careful out there. It's good to see everyone. The Judiciary Committee. It's good to be back together. This morning, we're going to take a look at some interim topics for the coming year. We've already been visiting a little bit, the chairman, as to what we might do location-wise, but we've got a hard stop at 9:30 today because several of us on the panel here this morning have conference committees that we want to sit down and visit about a couple of bills. So we'll try to hard stop at 9:30. Thanks to the good chairman next to me, he's kind of done some effort of blocking these together so we can take a look at some of these suggested topics by subhead, if you will. So I think the way we'd like to do this, law enforcement, let's take some of these ideas first, beginning with immigration accountability, cyberbullying, peace officer training, and fingerprint background check delays. That all falls underneath law enforcement. So if there's anyone here who would like to speak on immigration accountability, let's find it in our packet, folks. And
Page 6.
I guess page 6 is where that is. Maybe Representative Rodriguez-Williams, you'd like to say a few words about this one?
She's got to take a seat in front of us here.
Thank you, Representative, for coming around front where we can all see you. You sure could have stayed up here too, but this is good too.
Okay.
Yeah.
Thank you, Mr. Chairman. Mr. Chairman, I bring to and members of the esteemed Joint Judiciary Committee, thank you. I have had several constituents reach out to me on the topic of illegal immigration. And so I just want to come before the committee this morning with some facts and some potential ideas or things to pose before the committee. So last year alone, there were over 36,000 illegal immigrants that arrived in the big city to the south of us, known as Denver. And the mayor had said they can't deal with the influx despite its proud status as a sanctuary city. A recent poll showed that illegal immigration is the #1 issue for Wyoming residents at this time. This was just done a few weeks ago. And under current Wyoming law, voters only have to provide ID to vote. Illegal immigrants can obtain photo ID in Wyoming. So there's some concern about voting, as there's no proof of residence or durational residency requirements. In the last few weeks, we've seen horrific stories of murders and rapes that have been committed by illegal immigrants who were given red carpet access into our country. Two in particular that really stood out was 22-year-old Laken Riley that was brutally murdered by a Venezuelan illegal immigrant on her morning run in Athens, Georgia. And furthermore, an 11-year-old child was raped by a Guatemalan illegal immigrant in our neighboring state of Utah last month. So in a sense, the question that I've been posed with by many constituents is whether or not the state of Wyoming is prepared to handle this impact that we'll have on our justice system, our school districts, our public health system. I know that taxpayers in Denver alone are being asked to foot the bill for an additional $1.3 billion to increase their public school budget due to the influx that they've seen. And so there's a concern out there amongst Wyomingites. And again, I bring this concern to the body and just open it up. I'd stand for any questions.
Okay, thanks to the Vice Chairman on the House side. Any questions for Representative Rodriguez-Williams on this topic? Mr. Co-Chairman.
Thank you, Mr. Chairman. Representative, if you know, is there data available? I'm trying to figure out how we would find out more information about this topic, because I don't think that our arrest statistics and so forth are broken down by the immigration status of prisoners. And I just wondered the data sources that might be out there that you're aware of.
Yeah, thank you, Mr. Chairman, Chairman Washit. I didn't bring with me any specific data pertaining to Wyoming. Again, this would just be an idea for an interim topic. My hope would be that we would hear from agencies such as Department of Homeland Security, maybe our Department of Corrections, et cetera, and law enforcement on the ground. But I have personally heard from many of my constituents just kind of some anecdotal information that's floating out there, and concerns of illegal immigrants coming in to some towns via buses.
Go ahead, Mr. Co-Chairman.
Thank you, Mr. Chairman. So I don't want the data. I just want to, is there data available that you're aware of that breaks this type of information down for our use?
Go ahead, Representative.
Mr. Chairman, Mr. Co-Chairman, I don't know. And so I pose these questions again to the committee and just entertain the idea of bringing knowledge to the body so that we are prepared to answer these questions, such as the one I'm being posed with. Is the state of Wyoming prepared for this influx?
Okay, anything further? Okay, so Representative, Senator Cooper.
Thank you, Mr. Chairman. Not really a question, but a comment on this. I did have some inquiries from constituents concerned about rumors they've been hearing. I did have some talks with law enforcement last week while they were in here, from this town, from a county to the north of us, and from the west of us. They are concerned about it. They're very vigilant about it. You know, the rumors of the buses showing up, they're saying, no, we haven't seen that yet, but they are concerned about it. And they're very concerned about how they're going to handle it. I did ask, you know, what do we do with them now when they do capture one? And they said, you know, before ICE used to come around and with a bus and pick them up. That no longer happens. If they're not wanted somewhere else, they just have to turn them loose. And that's not the proper answer, I think. I think this is a valid concern.
Thank you, Senator. I think, folks, we're going to consider these topics, each one of us, as we go along. And you know, there might be some interest in at least finding out what's really going on out there. And information that we don't have, if we can find it out, that's going to help us and help us to visit with our communities. Representative, if you want to take the next one on our list, cyberbullying, that one is yours too. I guess before we do that, the co-chairman's right. Is there anyone else who wants to comment on this first topic, immigration accountability? Anyone else want to come forward and comment on that one? Okay, take it away on cyberbullying, Representative.
Mr. Chairman, with your permission, I just have one brief little handout, if I can just.
Absolutely, absolutely.
Thank you. Mr. Chairman, thank you. Mr. Chairman, members of the Joint Judiciary Committee, thank you for allowing me to bring this topic to you today. I was approached by local law enforcement about the topic of cyberbullying and cyber harassment. And I bring this issue forward to you and would like to draw a little attention to it and how it is becoming, how there is an increased need for potentially a cyberbullying statute within the state of Wyoming. It seems to be that there's an influx of this occurring within school districts and a large trend amongst youth. Again, I was approached by local law enforcement on this, and you have a little handout that's going around that gives you just kind of a little example of what occurs. So what information I was given is that these posts occur on social media. They're bullying related. They're often created anonymously using fake accounts. And law enforcement finds themselves in a bind that without any sort of criminal offense, they're unable to apply for a search warrant or identify the quote poster of the social media post. So they have difficulty tracking down who made these posts. I was also provided information that there are other states that do have cyberbullying laws. In the state of Michigan, they quote, thank you, a person shall not cyberbully another person. In Texas, there's language in their stalking and harassment statutes that integrate the use or abuse of modern internet-based communication tools and methods perpetrators use to cyberbully their victims. And so, again, this idea was brought to me, and I just bring it to you to entertain the idea of whether or not this is needed, whether or not we need to have further discussion with law enforcement across our state to see what kind of impact these cases have in our communities. And I stand for any questions.
Representative Harrelson.
Thank you, Mr. Chairman. So just kind of a statement as well as I guess maybe not even so much a question, but a statement, but I had a 19-year-old young man in my community commit suicide because of this. And it's very real. We a lot of times don't realize how much stock is placed into what's going on in the digital world around them. And this kid was bullied in a cyber fashion, or I would even maybe say blackmailed even. And he went out and committed suicide because of it. So it's definitely something we need to look at. I don't know if I'm not sure what we can do fully, but I definitely think it's something we need to be aware is definitely going on and definitely an issue. And as in my other role, I deal with this regularly of young people that are struggling because of just how mean they get in this world, so.
Thank you, Representative Harrelson. Representative Provenza, and then we'll come back to Senator Cooper.
Thank you, Mr. Chairman. I just kind of want to make a caution for future. You know, I've been getting a lot of handouts with children's faces on them this year, and I think it would be good due diligence to anonymize those children before we continue to kind of spread information with offensive things with their faces. So just for future reference, I would request that. Thank you.
I think that's a good caution. Thank you, Representative. Senator Cooper.
Thank you, Mr. Chair. I'd just like to reiterate what Representative Harrelson just said there. We lost a young man in one of my communities to cyberbullying in the last couple of months, and there really isn't any recourse for law enforcement right now to go really look into this further. At least not enough recourse for them. Thank you.
Anything else? Any other questions of the representative? Representative, thank you for bringing this topic. I too am very interested in this. On a related note, I just want to share, meant to do this at the start of the meeting, but I want to thank all of you who reached out the last week and a half. We've gone through some pretty tough times with our family. It's interesting. My brother was diagnosed with a brain tumor and underwent surgery a week ago. We discovered that he's been the victim of cyber crime. That's a related topic to this bullying piece. But I had the occasion to visit with our good friends over at DCI. And boy, it's tough. I mean, it's really tough for them to go after somebody, to find somebody, to really do this work. But that's a little bit of a related topic. I almost wish there was a way that we could put an appendage onto this topic and say, you know, let's take a look at cyber crime along with it. It's just devastating, you know. In the case of my brother, he was a vulnerable adult because of that debilitating situation that he was in. And we're not sure there's anything we can do about it. But there's hopefully something we can do about this cyberbullying piece. We're losing too many of our of our young people. And so thank you for that. Anyone want to come forward, any testimony or comment on this topic from anyone here this morning? Anybody online? Okay. Representative, thank you. Appreciate it.
Thank you, Mr. Chairman.
Okay, peace officer training, you find that on page 8 of your packets, committee. I know who brought this one. It's the co-chairman.
Thank you, Mr. Chairman. I did bring this topic. What I'm asking for is that the committee spend the interim taking a deep dive look at peace officer training throughout the state of Wyoming. We have an interesting situation in Wyoming where we have the Wyoming Law Enforcement Academy and the Wyoming Highway Patrol Academy, two distinct law enforcement training entities within the state. But I have, lots of questions about the types of instruction, and I'm not making any suggestion that there's anything wrong, but I think we should be, as a Judiciary Committee, at least aware of what our officers are being trained, how they're being trained, how many hours we spend training our officers compared to other states, the duration of different topic areas in the training. I suspect it is probably okay, but there may be much for us to learn about how that takes place and the satisfaction of the people of Wyoming and their agencies with the training that's being provided, the interplay between higher education and the academies. There's just lots of things that kind of spider web off of this topic. And I've always been of the opinion that the worst thing you can have is a poorly trained police officer. That officers who are not well trained make mistakes. They act in ways that we would prefer they not. And so I think it behooves the committee to be on top of the training issue in our state.
Questions of the co-chairman? Any questions? Would anyone here today like to come forward and comment on this proposed interim topic, peace officer training? Anyone from, is there anyone online? Nobody online? Okay, thank you very much, Mr. Co-Chairman. Fingerprint background check delays. I believe, Senator Schuler, I believe that's yours, isn't it? If I remember correctly? It might be,
Wyoming Youth Services.
I think it's yours. It is now. It is now.
this was actually mine, yeah. So I'll catch up to everybody this morning. I'm riding a little slower horse than everyone else this morning. So this actually came to me, as you can see, from the Wyoming Youth Service Association. And something that we ran into my years of working at the college, it actually was becoming an issue before I left there. And this is a topic that I think may not take a great deal of time, but deserves our attention. These background checks are beginning to take a very, very long time. That affects hiring processes. I think it can be really impactful on some of our agencies, et cetera. So pretty self-explanatory topic. I thought it was worthy of our consideration. So any questions or thoughts in this regard? Okay. Anyone like to comment on this topic? Please come forward. Good morning.
Good morning, Mr. Chairman, members of the committee. I'm Brian Anderson, the Executive Director with Youth Emergency Services and member of Wyoming Youth Services Association.
Brian, can you give us your last name again, please?
Anderson.
Yeah, thank you very much.
So I appreciate the committee's consideration in this topic. It was one that that came to us in one of our meetings, just as we've seen agencies, group homes, crisis shelters that have struggled to bring staff on board due to the fact that there's a long wait to do those background checks. Oftentimes not, and this is no way a judgment of DCI, they're doing a wonderful job. I mean, in researching this, they do around 33,000 background checks a year with 2 staff members. But there's other factors in there such as Wyoming weather and the mail service. And so oftentimes, in one of our members in Uinta County had a situation where the local police department was still rolling ink fingerprints. And after a week in the mail and then another week to get processed, it was found that the prints were smudged. And so this process started all over again. For those crisis shelters and group homes, due to our DFS licensing, we're unable to have those staff actually working on the floor until that background check comes back. Sometimes that's a barrier to the extent that we lose a staff member over it because, you know, it's an undue financial burden because we're having staff work that can't actually be effective on the floor, and then also those staff members sometimes maybe can't even start. And so we just appreciate the judiciary's work on this and considering it. Thank you. I'll stand for any questions.
Brian, thank you for that. Committee, anything for Mr. Anderson this morning? Appreciate you coming forward to enlighten a little bit further on this topic. Thank you, Brian. Appreciate it.
Thank you.
Anyone else want to comment on this topic? I see the director of our family services back there. Any thoughts on this front, or are you saving your ammunition, Director? I specifically, good morning, Director. I'll let you introduce yourself for everyone.
Good morning, Mr. Chairman, members of the committee. My name is Corin Schmidt. I'm the Director of the Department of Family Services.
So Director, thank you for coming forward real quickly. What kind of feedback are you getting on this front?
Mr. Chairman, we're getting the same feedback that Mr. Anderson had commented on, and this also applies to child care centers. A little bit about the process. We require a check of what's called central registry. And central registry is the database that we keep, the Department of Family Services keeps, that records substantiations when somebody has been proven to abuse or neglect a child or a vulnerable adult. Those types of offenses do not show up in a criminal background check. So we have our central registry system, and our turnaround time is about 2 days. However, then if it's a fingerprint, if the check requires a fingerprint, then that will go to DCI in their process. So sometimes, as Mr. Anderson said, we're willing to write a variance on our rules about background checks because we have a central registry check complete, but the criminal background check then takes a little bit. So I think it's a good conversation. I know it's a resource issue, so I think the committee should be prepared to understand that it probably is time, people, money. But certainly I think a conversation about the process would be helpful. I also know that they're held to a lot of federal standards around background checks because of the systems that they're accessing. So to some extent, my guess is that their hands are tied in some ways as well, but I think having an understanding of that process would be helpful. Certainly for us, it would be helpful.
Thank you very much, Director. Any questions for Family Services this morning? Really appreciate it. Thank you, Director.
Sure. Thank you.
Okay, let's move on. Speaking of the Department of Family Services Director, I don't know. This is your bailiwick, so you may have a couple things here, but adoptions from foster care, best interest of the child, I think that's the co-chairman's. So,
Thank you, Mr. Chairman. So, committee, I bring this topic forward based upon
that's page 7 and page 10.
page 7, page 10, adoptions from foster care, best interest of the child. I had several people come to me with just heart-wrenching stories where they were trying to adopt a child out of foster care, and it all looked like everything was going great, and they were, decorating the nursery and the bedroom and getting all ready, and then at the last moment, a parent shows up, gone through drug rehab, now they're, wanting custody of the child. The foster parents who are trying to adopt are terrified about the well-being of the child that they love so much. And so I just think there's a lot that we can learn about how this process works. And at least one of the topics that came to me was that in Wyoming, we have this overarching goal of reunification, family reunification. And the question that was brought to me by these foster parents is, where does the best interest of the child weigh in? Is there a time where the best interest of the child and family reunification may not be the same? And so anyway, I after listening to these heartbreaking stories, I know how difficult these family law kinds of things are for this committee to deal with. But I think it's a topic that we really need to dive into.
Questions of the co-chairman? Excuse me. Any questions? Senator Schuler.
Thank you, Mr. Chairman. I've had a few people contact me as well on this situation. And I think we're seeing more and more, grandparents and aunts and uncles that are raising their nieces and nephews, their grandkids, and it seems to be a more difficult situation once they've had them for a number of years for them to be able to adopt. It seems to be if they're in state custody, it's much easier for them to adopt, but if they're with, another family, and I know family reunification is always the thing that you shoot for, but what could we do with the courts to make that an easier situation?
Go ahead, Director.
Mr. Chairman, Chairman Washit, Senator Schuler, yes, these are all very, very tricky conversations. And I do think it would be a worthwhile conversation because I do think there's a lot of misunderstanding about how the system works, specifically the child welfare system. I know private adoption is also a topic that's been listed, and that is a very different conversation. But I do think that sometimes the two can blend, and just having an understanding of adoption, whether it be out of the foster care system or whether it be a private adoption, might be helpful. It is a big part of the policy, federal policy, that looks for reunification. And there's research that shows that children do better with family. Sometimes, though, that may not mean biological parents. It may mean siblings or aunts, uncles, grandparents, et cetera. So I think it is a good conversation. I think it also is interesting because we've also discussed a lot about parental rights. And as parental rights becomes a bigger topic for the state, also understanding then how that interfaces with the rights of those who are wanting to adopt or looking to adopt. It also is going to bring into the conversation a lot about our foster care system. And I saw that was also a conversation because I do think that is also a big part of the discussion. So of course, it's a policy call on your part, but certainly we would be willing to provide the education and the understanding of the system as it applies to federal law, state law, and then best practices.
So, Director, thank you for that. I was quite interested that we had 3 different topics come up related to this part of the world, and so committee for our consideration, all 3 of them kind of dovetail together. I mean, I think that could be our consideration as we rank this in our orders. On page 10 is that relative caretaker guardian adoption piece. And then, of course, we've got youth in foster care. That was a consideration for us. And so much to consider there. Anything else for the director? Okay, on any of those, let's take adoptions from foster care, best interest of the child, that topic that was touched on by the co-chairman, but also youth in foster care that and relative caretaker, guardian adoption. Would anyone like to come forward on those topics, on any of those topics? Any testimony on the foster care piece or? Okay. Director, thank you. So I'm not sure that we need to cover a whole lot more on the youth and foster care piece. That I would just commend to you to take a look at that one. Again, I would think that all three of those topics would probably fall under, maybe a half a day kind of situation where we could learn more about it. So anything else on that front? Okay, Judiciary subtitle, Order of Protection Statute on page 9 of your packet. Good morning, Ms. Butler. How are you this morning? Good to see you.
Good morning, Mr. Chairman, members of the committee. My name is Lisa Butler. I'm the State Court Administrator for the Wyoming Judicial Branch. And Mr. Chairman, I think this topic request is just an overall review of the protection order statutes in Wyoming. There are a few pieces of those that have proven difficult for our courts in terms of the process that they utilize. And so specifically, I'll give you a few specific examples, but I think just a general look at those statutes would be useful. One is a few years ago, the legislature adopted an amendment to those statutes that requires tolling of protection orders when the respondent, the person who has the protection order against them, is in jail or prison. And so those are tolled during that time, meaning if you have a protection order that's been issued for 2 years, and during that time, the respondent goes to jail, however long that respondent is in jail is tacked on to the end of that protection order. So if you're a year into the protection order, respondent goes to jail for a year, then when he gets out, or she, you have another year on the end of that protection order. The problem that we're running into there is that there's nothing that tells the courts that that has happened. So the courts don't actually have notice that the person is in prison. I could also surmise that this presents some difficulties for law enforcement as well, because the petitioner has the protection order that they originally were issued, and maybe they're trying to call somebody and say, hey, this person is violating this protection order, but it says it expires in 2 years, and we don't know if there's been a tolling period in there. And so that has created a little bit of difficulty just in terms of implementation. The tolling is automatic. Nothing needs to be filed with the court. And so, we don't issue a new protection order when that happens. So that's just one example. Another example is service timelines have proven difficult. So when a protection order is filed, the respondent is required to be served within 72 hours, or if there's good cause shown, that can be extended. It creates a problem because when that petition is filed, the court automatically sets that hearing right away because there is a timeline associated with those protection orders. So they have to set the hearing within so many days. If the respondent can't be served within that 72 hours, which happens quite often, then those timelines, those court dates have to be moved accordingly. And so it just bogs up the process just a bit. And so something to look at there is, something that could assist in helping to make that process a little more smooth. So, Mr. Chairman, I'll give you one more example, which creates, I think, more of a difficulty for our clerks than for the judges themselves. And that is there are 3 kinds of protection orders that can be issued in Wyoming. We have, we call them family violence protection orders, stalking protection orders, and then sexual assault protection orders. The stalking and sexual assault protection orders all live within Title VII. The family violence protection orders live within Title 35. They're all a little bit different, and one of the things that creates some difficulty is the confidentiality provisions around all 3 of those protection orders are different. And so we have to know specifically what kind of protection order it is. The clerks have to understand the statutes, and they have to pay very, very close attention as to which kind of protection order they're dealing with when somebody asks for information, because they're walking the line between providing that transparency to the public and then also protecting the folks who are involved in that protection order. And so kind of marrying those up would be incredibly helpful for our courts. And again, it's a policy decision, but something that could make it a little more uniform for our clerks and for attorneys, I think would be really, really useful. So, Mr. Chairman, those are just a few topics. And I know, I think Representative Stith also has a protection order interim topic on your list here today. And so I just think a real examination of those protection order statutes would be useful for the citizens and for the judicial branch.
Appreciate it, Ms. Butler. Thank you very much. Any questions of Ms. Butler? Any questions? Representative, come on forward. Anything for Ms. Butler? Okay. Thank you, Elisa. Very helpful. Appreciate that. Good morning, Representative.
Mr. Chairman, thank you. And so I agree with Ms. Butler that I think it makes sense to look at the stalking order of protection and the other domestic violence and the sexual assault order of protection statute. On page 1, this topic is proposed. I'm doing penance, I guess, for having played a role in killing 2021 Senate File 75, brought by the good Senate Chairman. I think it could make sense along the lines of what was then Senate File 75 to allow a party who shows up who's been accused of stalking to stipulate to the entry of the order without a specific factual finding of stalking or harassment. I think that could be useful. The problem is right now you can't do that, or if you do stipulate to a stalking order of harassment, stalking protection order, then you're admitting that you've harassed the person, and if you violate it, it's a 10-year felony. So the stakes are so very, very high, and so that really discourages people from entering into those stipulations. So there may be different ways of addressing it. I don't have a particular solution, but I think it's worth exploring that issue.
Representative, thank you. Senate File 75, I'm sure will be #1 on everyone's list, since it was carried a couple of years ago by a senator. I think this topic, committee, just from my perspective, seems to make a lot of sense. Just a little bit that I've delved into these statutes, it just feels like we have some inconsistencies. One of the things, Representative, that I wonder if you run into in your profession, line of work, it is sometimes mind-numbing, me working with students who were in situations where they really needed protection orders, and it just feels like to me on the front end of these that we make things very difficult to get one of those. That's not necessarily the topic, but it is related. I'm just interested in.
Mr. Chairman, I think that's certainly true from the victim's point of view, since I tend to represent the alleged perpetrators. They don't see it that way, but no, I think it's a topic worth looking at, because you want what you'd like. Obviously, the goal here is to prevent harm, right? The whole goal of these orders is to prevent the aggravated assault or the homicide that might result if there's no order in place. You want public safety and security, and so I think that's a common goal.
Thank you, Representative. Anything else, folks? Okay, we're good. Thank you, Representative Stith. Moving on, let's go with corrections. And Director, please come forward. We're interested to hear Correctional Officer Arrest Authority, Department of Corrections Contracting, Wyoming Board of Parole, Restoration of Rights Amendments, Prisoners' Personal Savings Account, and Medical Decisions. We have several topics, Director, as you're probably aware. First one up is, you can find on page 9, Committee, that Correctional Officer Arrest Authority. But Director, we're anxious to hear from you this morning in a general way, and then then let's take on Correctional Officer Arrest Authority.
Mr. Chairman, Co-Chairman, committee members, good morning. My name is Dan Shannon, Director for the Department of Corrections. To my left is Deputy Director Heather Babbitt. Mr. Chairman, in reference to page 2, 5, and 9, I would ask that respectfully the Department of Corrections withdraw 3 interim committee topics. I believe after further review, we can work those changes possibly through bills. The only one that we would have concern with is on page 2, and that's under Senate File 120, the restoration of rights.
So, Director, just hang on real quickly. I want to make sure that members of the committee, what we have would be taking off the list in consideration of the Director's request: Correctional Officer Arrest Authority, Restoration of Rights Amendments. Is that,
That's the only one I'm requesting to keep.
that's the one we keep?
Yeah.
Okay. I had written down 2, 5, and 9, so,
Inmate savings, Mr. Chairman, and also medical care decisions.
okay. Thank you. Go ahead, Director.
Committee members, I believe those additional bills we can work during the session next year, and I don't really want to take up the interim topic time. They're very important to the Department of Corrections, but I believe we can correct those with just a few small changes. The one that isn't, that we believe that would take some little bit of work, it doesn't have a fiscal impact, however, is the restoration of rights, Senate File 120. It's W713-105, which was passed by legislation during the 2023 session. As things rolled out, it's a very valuable program. We strongly believe in a restoration of rights for those who are qualified. With that being said, just a few examples. The statute required that alcohol, tobacco, and firearm, the ATF, be indicated. The ATF indicated in writing that they don't participate, nor will they be involved in it. We need to include our DCI partners. That's how the system works. That was excluded from the bill. The statute allows for multiple families as related to one course. That's a very open definition. I've worked through the Attorney General's office, but a related course of events is very subjective, so we have some suggestions for that as well. The statute would further update and indicate a second felony voids the certificate. So under original restoration of rights in 2018, which was our voting rights, we did not include the statement that if you have a second felony, it's null and void. It eliminates the certificate. So now we're going back on hundreds of them and rescinding the certificate of their voting rights because of that. So I think that needs clearly to be placed in statute. And once again, I don't believe there's any fiscal impact. It would take a little bit of work and provide others opportunities to give their input. It's just some cleanup from the bill. And one other, I think a topic that was recently discussed is the ATF sent notice to all firearm dealers in our state indicating that they're not going to recognize. What they don't recognize is a Wyoming citizen that has a felony conviction under a federal statute. It's not our citizens under our statutes. It's a person that's under supervision under the federal system. And that's caused some problems for our citizens in our state. So, Mr. Chairman, committee, I would ask once again that we remove the prior 3. I feel confident that we could work those bills next year, but this one I would ask the interim committee consider. I stand for questions.
So committee, restoration of rights. Representative Harrelson.
Thank you, Mr. Chairman. So this is obviously, I ran a personal bill working with Director on it as we saw some of these issues. I love the conversation of restoration rights. I think it's a beautiful conversation. I love the fact that there's high 400s, almost 500 people that have had this restoration of rights. But at the end of the day, my biggest fear is the last thing we want to do is set people up for failure. They're trying to do what's right. They're trying to be an upstanding part of society and get those rights back. And we don't want our statutes play into their demise or failure. So definitely think this is a vital conversation. Obviously, we just didn't have time this session to truly address it and touch it. But even yesterday on the floor, we were having conversations about this because there's just a lot of these areas where like we just don't know. So let's put all our heads together and figure it out. Do we have to remove someone's rights under Wyoming statute to be able to restore them? We just don't know. Let's have that conversation. So we've got different pools of thought, and I think it'd be really good for all of us to come together and say, hey, let's dig to the bottom of that barrel and find what's down there and make it right and have a really good mechanism so that they can do their job, and at the same time, we can sleep at night knowing we're not setting someone up for failure. So definitely think, very much a high priority for me on this one.
Okay, thank you, Representative. Representative Provenza.
Thank you, Mr. Chairman. I would like to echo that. I was a co-sponsor on that SF 120 last year and grateful for the work that we did. But I'm hearing from defense attorneys now as in some of those concerns. So I think it'd be good due diligence. I think there's multiple members on this committee that helped kind of sponsor that bill and get it through. So I think these are the people and this is the time to do that work.
Anything else, committee? Good comments made. I agree with both the representatives and director. I think that deserves our attention, and hopefully we can take that one up. We have a couple of other bullet items, but before we leave restoration of rights, anyone else like to testify this morning on that topic? Any final thoughts from the committee? Okay, so Director, we had several bullet items. I want to make sure we get to touch on all of them. We're gonna take three of them off, but what about the Department of Corrections contracting piece? Director, have you had a chance to look at that? That's on page 12, committee. Maybe we get a presentation on that one before you comment, Director, or you can take it away right now.
Mr. Chairman, I would ask that we have a presentation first, and I'll make a few
Okay.
comments with your permission.
Well, let's go to Department of Corrections contracting. Mr. Beggar, is he here this morning? Yes, please come forward. And then we have Wyoming Border Patrol. We have a suggested topic on that front, Director, just for your advance notice there. Good morning.
All right, thank you, Mr. Chairman. I'm Jason Beggar. I'm here on behalf of YesCare Corporation, which is a healthcare contracting company that has done work in Wyoming for a number of years. And I guess I'm going to be very careful with how I phrase things and say things. Everything that I'm about to say to you is documented, and we can go back and show things. But I guess what we're asking for is some oversight and shining some sunlight on corrections, their policies regarding transgender inmate care, and their management of a recent RFP for healthcare services. YesCare Corporation, or their predecessor companies, has held the healthcare contract for corrections for about 20 years. Typically, these contracts are written for multiple years with multiple option years afterwards. The most recent contract was awarded in 2021 with two-year options available. During the summer of 2023, Corrections announced that they would be issuing an RFP for a new contract that would begin on July 1st of 2024. In the RFP, YesCare noticed language inferring the new contract would cover transgender reassignment surgeries and other surgical treatments of gender dysmorphia issues. This coverage is 100% new and had not been previously covered. When questioned about the coverage, we were told a 10th Circuit Court case now mandates coverage. The company is well aware of an Idaho case out of the 9th Circuit, but nothing in the 10th Circuit that oversees Wyoming. The company has not received a response to date when asked for clarity regarding any cases in the 10th Circuit that would impact Wyoming. Following Corrections' decision to award the contract to a new company, YesCare had many questions, as quotes from a third-party auditor stated, "This is probably the best performance and outcomes we've seen in years. and the care is excellent, and patients are getting first-class care and treatment across the board. After receiving the results of a records request last month, it was revealed that corrections selected a vendor with a bid that was $9 million, which was 18.5% higher than a competing bid. In their JAC budget narrative, corrections acknowledged a 12% inflationary increase between 2019 and 2023 and anticipate significant cost increases. Their budget request asked for an additional $4.5 million to cover healthcare services. However, the existing contract corrections could have exercised would have locked in earlier pricing. Wyoming would save $30 to $40 million over the life of the existing contract had corrections exercised the options. All of these issues warrant the committee to look into this further and ensure the policies align with the political priorities of the legislature and that a significant contract is the most fiscally prudent for the state. Thank you, and happy to answer any questions.
Okay, thank you, Mr. Baker. Questions, Representative Provenza.
Hi, thank you, Mr. Chairman, Mr. Baker. YesCare and Corizon, I believe, have been sued over 1,000 times across the United States because they have not provided adequate health care to incarcerated folks. So I guess I'm just, and quite frankly, I've gotten complaints from people that have folks that they love inside about Corizon. So, this is kind of the first that I'm hearing about this, but this is a company that has a long track record of issues. So I guess if there's concerns about contract, I mean, I am a little blindsided here, I guess, by this conversation and what the actual issue is with Department of Corrections if they're trying to protect Wyoming's taxpayer dollars.
Further questions? Any questions of the bringer of the topic for our consideration? Anything from the committee? Go ahead, Representative Oakley.
Thank you, Mr. Chair, and it might not just be for the bringer. I'm just interested, so maybe for the DOC, has policy changed regarding transgender inmates? If so, where is that written? And finally, do we have people incarcerated that are not their biological sex in Rollins or Lusk?
So, Director, if you could keep that question in mind, we'll come to you in just a second. Anything else for Mr. Baker? Okay. We may come back to you, Mr. Baker, but I want to get to the director. So, Director Shannon, can you maybe address Representative Oakley's question?
Aye. Mr. Chairman, committee members, Representative Oakley, thank you for the question. Our transgender policy has been out since 2021. It has not changed. We have no we do have females housed at Torrington. We do have females housed at the Wyoming Honor Conservation Camp in Newcastle. They have no access to males. And we have no one. We've not done any surgeries. We follow the courts. And we don't. So, Mr. Chairman, if I may.
Go ahead, Director. Absolutely.
I, as well as Mr. Baker, I'm hesitant to comment because I think I'm trying to be baited here. But I can tell you this, it is correct that we've had contract with YesCare for over 18 years. The contract expires June 30th as confirmed by the Attorney General's office. I put an RFP out. I wanted to see what's best for our state. The fiscal number is incorrect. So I am cautious because we are negotiating with a new contract at this time. I can tell you through the RFP, through procurement, no individuals that participated contested the contestant period. There's been no violations of RFP. So to me, when you make the hard decisions and you do what's best for our state, this is what happens. I think it's surprising that you talk about transgender. We follow the courts. Our policy clearly only identifies how we operate and how we move inmates. The Department of, you don't want the Department of Corrections making medical decisions. It would be Yes Care that makes a medical decision, not the Department of Corrections. And with that being said, the RFP, there's not one word of transgender in that RFP. So I'll stand for questions.
Any questions of the director? Okay, thank you all. Appreciate it. Director, if you'd like to stay put, I just want to make sure we cover everything under the bailiwick that you might want to comment on.
Sure.
The next one, committee, is found on page 3 of your packet, the Wyoming Board of Parole. Representative Namick, do you want to, is that the parole one or? Yeah, I think it's yours, Representative, isn't it? There we go.
Thank you, Mr. Chairman. I was approached by the parole board about escapes from a ACC facility. If the individual comes back late, they're charged with escapes. So maybe we need to look at the statutes there and tweak them a little bit. You know, they're not really escaping, they're just late, but that's the crime that it's falling into.
Okay, any questions of the representatives? All right. Welcome, good morning. Appreciate you being here. Please introduce yourself for the folks.
All right, good morning, Mr. Chair, co-chair, committee members. I'm Jeff Lamb. I'm the deputy director with the Board of Parole. Essentially what we've discussed with Representative Namick is a look at statute 713-402B. That statute deals with 2 offenses if committed by inmates, makes them ineligible for parole. Those 2 offenses are the first one is assault with a deadly weapon on a correctional staff or on another inmate. The other is escape or attempted escape from a state institution. We see there may be some inequities in how those are handled. Number one is with either offense, it has a big difference to someone who's serving an offense of say 3 to 5 years to be ineligible or declared ineligible. It's a totally different thing for someone that says that may have a sentence of 60 to life. In one, you're making them ineligible and essentially adding 1.5 years, maybe 2 years to their sentence. In the other, you're essentially giving them a life sentence. So we would like that situation looked into and the possibility of putting some caps on those ineligibilities. For instance, if we have a minimum sentence of 10 to 20 years, a cap of 5 years of ineligibility. If we have a minimum sentence over that, perhaps a cap of 10 years. And so those are what we want to look into. In addition to that, with the escape, Representative Namick did mention that the adult corrections, correctional centers. We do have an incidence where there are times where it's not really an escape, but they are off schedule. They did come back late, and yes, it should be a disciplinary thing, but maybe not something that would make them parole ineligible. And so we ask that we look at adding some mens rea into that escape statute, discussing some actual intent behind that crime. Also, with the assault with a deadly weapon, we would like to change that and just refer to as an assault as defined in the aggravated assault and battery statutes. What that does is that makes it to where we can also consider serious bodily injury and those types of assaults. Both of these things are rare occurrences, but they do come up, and we do have assaults in the institution where we might not have a weapon used, but we have some serious injuries. People getting life flighted after assaults within the institution, and things like that. And so we just want to be able to refer to the aggravated assault and battery statute and use that to lean on when we're making these decisions.
Mr. Lamb, thank you. That's very helpful. Mr. Co-Chairman.
Thank you, Mr. Chairman. Mr. Lamb, welcome. Yeah, I was thinking that in all my years on judiciary, this is the first time I can recall Board of Parole coming before the committee. And I think that this is a great topic, and if nothing else, it gives the committee a chance to learn more about what the Board of Parole does, your statutory duties and how you function. I think it's a worthwhile topic.
Yeah, I appreciate it too. Committee, anything for Mr. Lamb? Representative Oakley?
Thank you, Mr. Chairman, and I'll be brief. Excuse me. I think it's interesting. I guess I wanted to ask, that makes it appropriate, but do you see like a big difference between, it's funny, so there's two things that make this happen. One, as you said, is aggravated assault on a corrections officer, and the other is something that, while not all, but some could be possibly getting off schedule. So do you see the kind of the difference, or maybe we look into the different things that could make you ineligible beyond these two things? What do you think about that? And then just in general for the range of this?
Mr. Lamb, go ahead.
Mr. Chair, Representative Oakley. We think it's worth a discussion because, it's not just necessarily the fact that on the escapes that there's no intent behind the law, but there's also a part in there where different judicial districts respond to those escapes differently. Some people get charged criminally. And if they get charged criminally, then by our policies and by statute, they are ineligible. If they get convicted, I'm sorry, not charged. We have other areas of the state where they are not charged criminally. And so what we as the Board of Parole are working off of is the ACC discipline or the DOC discipline records, in which case there is a rebuttable presumption on those. And so we actually have hearings to decide that, where the parole board decides that. And so by adding that mens rea in there, that eliminates that a little bit and takes out less contention on whether they are criminally charged or not. I hope that answers your question.
Any follow-up, Representative? You good? Thank you. Okay, anything else, committee? Thank you, Mr. Lamb, appreciate it. I share the interest of the co-chairman. It's good to see you, and good topic for our consideration. Director Shannon, anything on this particular topic? You're welcome to chime in.
Mr. Chairman, committee members, just a few comments. We being a Department of Corrections, would strongly support this discussion. I think it's something that merits a good conversation. In reference to the different forms of sentencing, if a person's doing a 2 to 5 or a person's doing 25 years, we have no control over what but we're the ones that are impacted by the assaults. And with that being said, we'll do everything we can to charge those individuals, but you have to be cautious to balance it on the other side, and we can get into that later if you choose to pick that up, but you also teach people with shorter sentences to create more assaults. Concerning the escapes, Deputy Director Lamb is right on target. We instituted a policy change approximately 2 years ago where we only consider an escape if I issue a warrant for them. And there's a form of criteria that they have to meet, because we did have individuals that would be gone 10, 12, 14 hours before it was even reported, and some citizens were injured or severely hurt in our community. So I changed that. And once I signed that warrant, then I won't call. It'd have to be pretty rare to call it back. So I set the criteria, but I think that's something we can discuss and get some good input in. So I strongly support the notion.
Okay.
Thank you for allowing me to speak.
You bet. Thank you, Director. Appreciate that. Anything else, committee? Mr. Lamb, thank you again. I'll let you fade back, and if there's anyone else who would like to testify on this topic, you're welcome to come forward. Okay, that kind of wraps up our considerations for corrections type issues. And let's go to what the co-chairman identified as just legislative type considerations. Plain English statutes, that's page 1 of your packet. And Representative, that belongs to you. This is Representative Chestic, plain English statute. Do you want to take it away?
Thank you, Mr. Chairman. And this is a little thinking outside the box kind of creative topic. No particular legislation in mind, but just an exploration of a topic that I think we owe it to our constituents and citizens to think about. We tend as a legislature to write statutes that only a lawyer can love. And a lot of times even the lawyers don't love them because they're very complicated, very legalistic, very jargon-filled, convoluted, very difficult to understand. And the Green Book is full of statutes. And we as a legislature oftentimes have a hard time understanding what we've written. There is a better way, potentially. And this is a relatively new topic in my world of legal writing, and that is plain English statutes or narrative statutes. It's a way of writing a statute that you don't need a law degree to understand. You can use examples, you can use categories, tabulations, lots of techniques that you can use to draft statutes that are more comprehensible to lay individuals who must follow the law. They need to understand what the law is. If they can read a statute and understand clearly what it means, that's going to be a benefit to them. I'm not asking for a lot of time. I think what I envision is there's a recent article published a couple of weeks ago in the Journal of Legal Writing about this technique. I would like to invite the author of that article to come testify for 15, 20 minutes, half an hour tops total, to describe this technique to us, if only to alert us to the fact that there is a different way, I think a better way of drafting statutes. What comes from that, who knows? Maybe nothing. Maybe we can come up with some kind of a statement or principle of a preference for plain English drafting. Maybe we could actually start drafting a few statutes using this technique. So I'm just proposing that we study the idea of drafting plain English statutes using narrative drafting techniques. And let's hear the author out, maybe half an hour. And I think it's worth at least considering. Just my idea.
Thank you, Representative. You know, your narrative kind of reminded me of the good old days of Senator Massey from your neck of the woods. He was kind of our police force on that front, and he wasn't afraid to get up and say, this sentence just doesn't make any sense. And so we miss him. But anyway.
Mr. Chairman,
go ahead, Senator Case.
Before Massey was Matilda Hanson, and you have no idea of language, please. She searched and found most of the suches in the world and fixed all the suches, and there's a few left for Charlie Scott to do, but she was amazing.
Yeah, we've managed to get a lot of such ases. Committee, anything for Representative? Go ahead, Representative Crago.
Thank you, Mr. Chairman. If this ended up becoming a bill, I was wondering if we could name it the Lawyer Income Reduction Act.
Yeah, there you go, Representative. You've got a good idea. You got a good start on it. Thank you for bringing that. Very interesting. And let's go.
Wait for just a minute, so let's move to this.
Oh, okay. We're going to jump down to fixed monetary amounts throughout the Wyoming statutes. And that one is Senator Schuler's, I believe. Senator, take it away.
Thank you, Mr. Chairman. I had a conversation the other day with Marcia Shaner from the Wyoming Trial Lawyers Association, and we talked a little bit about how a number of our statutes have not been really looked at or assessed based on inflationary issues. And you think about some of these, have been there since the 70s, 50 years ago. And we thought it might be something that we might want to take a look at. And I know Marcia's here, so I'd like to have her come up and anybody else you'd want to bring. And she can probably give you specific examples better than I could. And
yeah, please come forward. Thank you. And well, Senator, thank you. That's a shocker that we haven't kept updated on a statute. But given that, good morning, ladies. Thanks for being here. Please introduce yourselves and clue us in on this.
Good morning, Mr. Chairman. Good morning, members of the Judiciary Committee. I would just like to begin by thanking you all for your hard work this session. We spend most of our time with all of you and appreciate you very much. What really brought this to mind was Representative Crago's bill, which did not make it through the process, which was to change the amount of the number of dollars that are required for a minor to have placed in a trust or a conservatorship or something of that nature. It used to be $5,000 and his bill would have increased it to $25,000, which just makes sense in terms of our times and dollars. And then we have been looking at the Governmental Claims Act for a lot of years, as many of you might know. And that initial bill or initial statute was passed in 1979, changed in 1986. And those monetary amounts in there, the caps are very old, decades old, and really don't serve the persons who are harmed by a governmental entity anymore. $250,000 in 1986 is worth $701,000 and $614.82 today. And so there's a big disparity. I heard some conversation yesterday or discussion on the floor of the House about veterans exemptions and how those are very behind the times. And we were just thinking, it seems broad, maybe we could choose some areas to start looking at to bringing up for inflation, because we're pretty behind in that area.
Yeah, thank you very much, Ms. Shaner. I'm not sure we would put 7,001.648 in the statute, but we can sure take a look at it. Good morning.
Good morning, Mr. Chairman. Beth Lance with the trial lawyers. This is, I think, hopefully at least easy to understand. It certainly would take time for LSO to peruse all of the books, right? Because we would be looking to potentially update anywhere and everywhere for inflation. However, hopefully, it's just a very straightforward ask, right? There are unfortunately several places within the statutes where we do have specific numbers, and in almost all cases, unless it's been passed maybe in the last couple years, we know those numbers are going to be outdated. We have seen a really high increase in inflation in this country, and so our numbers within our statutes are certainly old. And so I think it would definitely be just a great way to get into our statutes and make a big difference for all constituents in all kinds of areas of the law, in order to ensure that these monetary values are up to date.
Ms. Lance, thank you. We'll go to the co-chairman in just a second, but I wanted to thank both of you for all your efforts during the session, all the help that you provide to both sides of our legislature, and so thank you for that. Mr. Co-chairman.
Thank you, Mr. Chairman. I just wanted to ask if it would be a huge endeavor to go through all the green books. If we had to choose a few titles to start with, is there a priority list of where you think is most important for us? Is it in that governmental claims arena or criminal statutes? Looking for some guidance.
Yeah, Ms. Lance, go ahead.
Yes, Mr. Chair, Mr. Co-Chair. I would say yes, from our perspective, the Governmental Claims Act is, I think, one of the most important. As you heard, that's just such an enormous disparity. That number of 250,000 is just so old. And so we aren't really providing our citizens the coverage that I think they deserve to have there. And so certainly that would be a priority. I think it is, again, I go back to Representative Crago's bill this year, these kinds of numbers that fall into areas where we're looking in civil law overall, right? I think civil tends to be maybe the priority over criminal. Criminal, we're looking at monetary penalties for crimes. I'm not sure I'm hearing that people feel those are necessarily completely out of the realm of reasonableness at this point. So I think certainly in that civil area.
Any further questions of our trial lawyers? Senator Case.
Well, Mr. Chairman, we have to be a little bit careful here. We run into constitutional prohibition about combining different subjects. So, for example, if we had very disparate things that we're changing the fees on, maybe game and fish and maybe birth certificates, or, and they're in the same bill, you can't really stretch this and call it fee changes across state government and get away with that. You could probably do titles, so I'm just cautioning, you have to be a little careful.
Yeah, appreciate that, Senator Case, and I do want to give an opportunity to Mr. Fuller, just giving a warning that we may offer you an opportunity at the end of today's meeting to offer any thoughts, but appreciate the conversation. I think it's spot on. We may have to rely on our friends to be a little bit more focused in what we might want to consider. But anything else for the trial lawyers this morning? Okay, thanks, both of you. Appreciate it. Anyone want to come up and testify on this topic? Any additional testimony? Okay, let's move on to what I think will be the last proposed topic, statutory right of appeal in criminal cases. Representative Oakley. That is on page 4, committee. Thank you, Representative, for coming around where we can all get a look at you and have a little dialogue on statutory right of appeal in criminal cases.
Yes, so thank you, Mr. Chairman, members of the Joint Judiciary. So I bring to you what I think is a fascinating issue, and one that I think we can really do some good to ensure fairness for both sides of the aisle. In any legal case, all you're looking for is that both sides have an equal ability, a fair ability to have their case. And the state seeks the same, right? Which in the state, in the criminal context, of course, represents the people of Wyoming. And it's important that it stay fair and balanced. So what we'd be looking at is a statutory right to seek review of criminal cases in circuit or district courts. So when the state believes that evidence was suppressed, for example, and the judge got it wrong, improperly decided that. The way things have gone, and we can discuss how we got here, but basically the state doesn't have that right. Judges are just human. They get some things wrong. Or at least the state should have the right to make their argument. Because what you're looking at, of course, is if in using this example, there are other issues, but sticking with the suppression of evidence, that's probably going to be the end of the state's case. So if you don't have that evidence to, of course, to present to the judge or jury, you don't have a case. And so currently, two things. There's the statutory provisions are 712, 102 through 104, which says that the state is permitted to take a bill of exceptions, and that's the route by which the state can do that. But the thing is, that doesn't affect that case. So you don't get an appeal on that case. It's prospectively, which in that instance is not helpful. And then the other process by which the state could use is a petition for writ of review. The problem with that is that that's discretionary, and it has there have only been 5 of those taken up since 2005. So in essence, it's not really done, and it's not really available. And I think this is important Wyoming is the only state in the country that does not afford the state the right to appeal these decisions in criminal cases. And so it's something we can look at. And, you know, like I say, via our statutes, they say this bill of exceptions. And then, of course, there've been cases that, you know, have come out, but it's interpreting what currently is. And of course, what we'd be looking at is making it a change and making this fair for the state. Again, the majority of states allow the state to appeal suppression orders, orders dismissing, judgments of acquittal, you know, orders granting new trials. So that's what we'd be looking at. And I'll provide you with the case, kind of an interesting case that kind of, I guess, highlighted it for me. There was a case in Sheridan. The defendant sought to suppress the evidence. It was marijuana, and it was for the search. They wanted to, and the judge granted the suppression of the search. Therefore, you know, no marijuana. But in doing so, the judge referred to, as part of the decision-making, said, well, this defendant was in my court 5 days after this happened, and took judicial notice of her demeanor, which I don't think is appropriate. I'll just say that. And neither did the attorney. And so they sought, of course they sought the review from the district court, which is, you know, in a circuit court, so your misdemeanor level, then your first appellate court would be the district court. So that judge reviewed that and said that was inappropriate and overturned the suppression from the district court. Supreme Court takes it and says, well, you might have been right, you shouldn't have granted that. You shouldn't have granted that interlocutory relief. So that's kind of one of the impetuses that got us here, is that it really kind of makes clear that the state just does not have that opportunity. And the reality is that's not fair. The state should have full and fair ability to articulate their case and make sure that they can keep their evidence from being suppressed. So that's what this is. And I think it's an interesting and a fun topic, and I hope you'll support hearing it in the interim.
Thank you, Representative. Well done. Any questions of the committee this morning for Representative Oakley? Anything? Oh, Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Thank you, Representative Oakley. Just curious, to your knowledge, has this topic, or has there been a past bill that's been attempted in the past on this?
Representative, go ahead.
Mr. Chairman, Representative Rodriguez-Williams, I am not aware of that, but I certainly, so I don't think it's something that's been tried and resisted, I guess. I don't see that in review of the cases. So again, basically, since this statutory scheme exists, the reviews have kind of been sort of on a constitutional review. And so there's been case law that's kind of actually even, it's very limiting, that's gotten us here. But I don't think this is something that's undertaken. And honestly, again, some of the things that, I'll just say it, that might create an imbalance and unfairness to this sometimes is that, like, the Attorney General probably isn't going to bring things, and the prosecutors, you know, we don't seek relief very often, right? It's because if we lose whatever the broader side of the state or prosecution, like, it's okay sometimes. It's okay, you know, you can say, oh, this one person got away with something. So that's okay. So a lot of times, we call ourselves, you know, we'll be the adults in the room or something like that, but so we don't pursue those things. But I think it can create a true imbalance, and I think, and when I look at that, that's what I believe that I see here.
Thank you very much. Thank you, Representative. Anyone want to testify on this topic? Anyone else want to come forward, offer any testimony? Interesting topic. That concludes all of the interim topic suggestions that we had in front of us this morning, committee. Just by way of just procedure, I think the way that we handled it a year ago, where everyone gets the opportunity to weigh in and provide your chairman with priorities that you think we ought to consider as a committee, I think that was helpful. If you have a topic or two that you absolutely don't want in front of us, please tell us that. And all the way through the process, I know the co-chairman very well, and I certainly am wide open to making sure we take up the topics that the committee thinks are relevant and important. So please get started ranking those for us, and in the next couple of days, try to get those back to us so that we have them. And then, of course, that goes to the Management Council. Your co-chairman and I will take those on up the ranks. I think we've got some good topics for consideration, Mr. Co-chairman.
Thank you, I agree. And just encourage everybody to get your comments back before we leave. And we'll then, the co-chairman and I'll work them through and come up with a list that we present to Management Council. And maybe Mr. Fuller.
Mr. Chairman,
Go ahead, Senator Cooper.
can you give us kind of a timeline on when you want this? We're all doing several of these, so if you could kind of give us.
You know, it's very helpful if you get those, you know, before we take off, which we're all, I think, pretty excited to do. So if you can do that in the next couple of days, it would be really helpful. If you miss, you can get them to us when you get home, but I think we're all going to try to forget for a while, you know, so we'll work very hard to see if we can't categorize these and pull them into form so that we have good, productive days. You can tell that we have topics that naturally go together, that they're married at the hip. So we'll work diligently on that. Any other thoughts from the committee this morning as we go into another interim? I want to thank you all for the hard work. There have been some whitecaps on the water, but the boat hasn't hit a sandbar yet, so, you know, we've managed to, yeah. So Senator Schuler.
Thank you, Mr. Chairman. Again, just wondering again if you have those dates in mind. And I'm sure it's probably somewhere on the website, but just to be safe, do we have those available?
Mr. Fuller? Okay. Mr. Fuller, thanks. You were next up. I was just going to give you an opportunity to offer any thoughts regarding what we've heard this morning, and we sure value having you alongside. Thank you.
So, Mr. Chairman, members of the committee, first in terms of comments, I think any comments are probably just premature. Not knowing, number one, what the topics may or may not be, you know, what the will of the committee may or may not be in considering those topics. So
sure, fully understand that.
Yeah, nothing to offer this time, but certainly we'll chime in later, I'm sure.
Can you remind us of those dates? Maybe that would be helpful.
Mr. Chairman, definitely. So the dates that were selected are June 10th and 11th. And per you and the co-chairman's direction, that meeting is slated for Casper. September 19th and 20th, tentatively slated for Cheyenne. And then November 7 and 8 in Casper.
Committee, and thank you, Mr. Fuller. We did talk about maybe trying to get up to the Bighorn Basin, visit the boys' school, if we were able to do that, but we'll look into that a little bit. I think that's a good place to start. Certainly the dates are locked in, so. Mr. Fuller, anything else for the good of the cause this morning?
Yep, nothing on my end, Mr. Chairman.
Thank you very much. We have about 3 or 4 minutes before our hard stop this morning, and we have a couple of conference committee groups that want to meet, so appreciate it. Anything else for the good of the cause, committee? Thank you very much. We are adjourned this morning.